Hi, good afternoon, good evening, everybody. I hope everybody's doing well. Uh, Today, we've got a short webinar. We've got only a 30 minutes webinar, and unfortunately, Chaitanya from CII and CLA couldn't join us. So I'll just be sort of diving in. Hopefully, we can finish in time then in half an hour. So I'm just going to share my screen now. If anybody has any problems, please sort of do let me know just on chat, or maybe probably easiest if you unmute yourself and just let me know that you're facing problems, so then I would know, because I may not be able to monitor the chat while I'm presenting my screen. So thank you everybody for joining. Like I said, welcome to the September edition. This is a short webinar. We don't have a panel discussion or a knowledge session today, so I'll just be covering the updates. But we have some very important and relevant updates today. So we're going to discuss 5 decisions today. For those of you who've been attending previous webinars, I think the last 2 or 3 webinars was quite heavy on the sort of the Delhi and the Bombay High Court decisions. Today we've got 1 from Bombay, 1 from Delhi, and 3 from the Supreme Court. So we've got a good mix today. So moving on to my first decision, but just before that, in terms of housekeeping, if there's any questions or if anybody wants to share any thoughts, any comments, or if you have any experience on the subject or the decision that we're sort of discussing, please feel free to unmute yourself and share your thoughts and discussion and join the discussion. So moving on to the first case. Sorry, I realized my video has gone off, so I'm just going to turn on my video. Yeah. So the first case is the ONGC versus the consortium of Sine Darby Engineering Limited, Bombay High Court decision of the 3rd of July. The issue here is essentially in the appellate, mainly it was an appellate sort of issue, and whether an order rejecting amendments to a set-aside petition falls under the ambit of Section 37 1C of the Arbitration and Conciliation Act. So taking a step back on the facts, essentially ONGC had awarded a tender of works to Sine Darby, and then a dispute arose under the contract. It was arbitrated, and the award was issued in favor of the respondents against ONGC. As part of the proceedings, the arbitrator had rejected the counterclaim or denied the counterclaim by the ONGC. Now, ONGC launched Section 34 proceedings before the High Court. It submitted a petition, and then it actually took out a chamber's summons to amend the petition and add certain grounds to challenge the award. Now, the chamber summons which were taken out had 3 categories of different changes that ONGC wanted to make in the Section 34 petition. The first category was challenge the counterclaim of the appellant being rejected by the arbitrators. So ONGC's counterclaim being rejected, that was category 1. Category 2 was basically just an elaboration of the existing grounds of challenge regarding delay and liquidated damages. So 2 of the issues which were already there in the original Section 34 petition, it was just an elaboration of that. And then category 3 was individual claims which were not really raised during the contract work, but were claims as additional work as part of the contract. So these were sort of 3 categories of changes that ONGC wanted to make to its Section 34 petition. The single judge before whom the chamber summons were issued and amendments request was made, allowed category 2 and denied categories 1 and 3 as new grounds made outside the limitation period submitted. ONGC then filed an appeal under Section 37(1)(c) of the Arbitration and Conciliation Act to the division bench. So the submissions by the ONGC before the division bench were that it basically principally relied on the effects test, which was propounded by the Supreme Court or elaborated upon in the Chintel's India 2021 decision. For those of you who've been attending the webinars recently, we did a deep dive and discussed the Chintel's decision in an earlier webinar. But in summary, effects test is basically, the Supreme Court says it's part and parcel of the statutory provision of Section 37, which deals with appeals, and it is an express language within Section 37(1)(c). ONGC argued that the effect of the order dismissing the application for condonation of delay is that the application under Section 34 comes to an end. So consequently, an appeal under 37(1)(c) would be maintainable against the order if using to condone the delay in filing a Section 34 petition. So that's essentially how the Supreme Court argued that the effects test, should apply here. And the single judge basically rejecting Category 1 and Category 3 of its proposed amendments will fall under Section 37(1)(c), so its appeal is maintainable. Respondents, on the other hand, said, appeals are maintainable against orders where Section 34 grounds are considered. So they principally relied on BGS Soma versus the NHPC decision. Again, a decision which we've considered in detail before. And they said, only in cases where the Supreme Court, only in cases where any court has actually gone into the details and considered Section 34 grounds, then rejected it, only then an appeal is maintainable, and not really, when you refuse certain amendments to a Section 34 petition. So the court said, distinguish it from Chintels. It said that there can only be one Section 34 petition. So the court looked at in detail at the three categories. So Category 1, one counterclaim being rejected by ONGC. Category 2 was, of course, just an elaboration. And Category 3 was various individual claims which were not raised during the contract, but as additional work. So the court said there can only be one Section 34 petition. You can't file one and then amend one, and in principle really have two Section 34 petitions. Another thing to keep in mind is that the amendment was actually made, or the request for amendment was made after the limitation period expired. So that's also something that the court weighed when deciding whether to allow the amendments or not. And rejection of Category 1 amendments still leaves Section 34 petition, and what can be annulled on other grounds. Even otherwise, the court cannot grant the counterclaim to ONGC. So the court basically said, there's no point allowing Category 1 amendments because in effect, the court cannot really award the counterclaim to ONGC. That was for the tribunal to decide, and the tribunal clearly denied that. And the court said the effect of this is, when it distinguished from Chintel, it said the effect is not really distinguishing or bringing Section 34 petition to an end, which was the case in Chintels because it dealt with sort of the limitation period and other things. So it said that ONGC can still argue what it originally argued in Section 34 petition. So you can't really argue that the effects test is applicable here. Essentially, it says, denial of certain grounds of appeal on its own neither forecloses the challenge, nor does it necessarily spell the end of a Section 34 petition. So to put it in simple words, if I file a Section 34 petition today with 10 grounds, and I want to add 4 more grounds later, the 4 more grounds are rejected, that's fine, but that still leaves the 10 grounds in place on which you can still succeed in a Section 34 petition. So the effect of rejection of those 4 grounds does not really mean that your entire Section 34 petition is out, which is really what Chintel said. So the court said, that appeal is not maintainable under 37(1)(c), and it upheld the order of the single bench of the High Court, which was essentially allowing only Category 2 changes. So that's the end of this decision. Unless anybody has any comments, any questions, any thoughts, I will move on to the next decision. Anybody wants to share anything? Okay, moving to the next decision. This is the Delhi High Court decision of July. Atindra Construction Private Limited versus Gale India Limited and others. The issue was basically whether misrepresentation or suppression of facts satisfies the definition of egregious fraud. The factual background is that Atindra was awarded a tender for works by TEPL, which was respondent number 2, and TEPL was acting on behalf of GAIL, so Gas Authority of India Limited. There was an unconditional performance bank-based guarantees in place, which Atindra had provided to the respondents. Now, GAIL terminated the contract and invoked the bank guarantees. Atindra then applied for interim relief to stop the invocation of the bank guarantees. So that's the sort of factual background. The arguments which Atindra made to stop GAIL from calling on the bank guarantees is that GAIL, as part of the contract documents, had a soil testing report which indicated that hard rock was present, but it was actually at a much deeper level when Atindra actually looked at the site and inspected the site. So this argued that this was misrepresentation in a ground for stopping the invocation of bank guarantees. It made no allegations of fraud before the court. Gale argued that contract mentioned that Atindra could conduct a survey themselves, so they did not have to really rely upon the soil testing report. They were free to conduct a survey. And Gale argued that, egregious fraud is the only ground for stopping invocation of bank guarantees, and misrepresentation isn't a ground. So the court agreed. The court said, that the court looked at the contract which states contract decide whether they will use the survey report for HDD profile or they will go for fresh survey. Responsibility was held with the contractor. So the court said there was no misrepresentation because Atindra was free to get its own soil testing report as per the contract. And the court looked at the previous law and they said that if a court wants to stop bank guarantee from being called upon, there are only really two grounds. One is egregious fraud and the other is special equity. And if there has to be a third exception made, which Atindra was arguing to be misrepresentation, then that exception would have to be akin to irretrievable injustice or putting a party in an irretrievable situation, which was not really a case here. So pure misrepresentation, factually, the court said there is no misrepresentation. But even if there was misrepresentation, that's insufficient for the court to order Gale to stop the bank guarantees, calling on the bank guarantees. The court heavily relied upon Svenska versus India Charge Chrome decision, a very old decision of 1994, but that clearly is still the law of the land. And if I'm going to read the relevant parts, because I think this pretty much summarizes what the present law is if you want the court to order stopping of bank guarantees being called. So it says, and I quote, in case of confirmed bank guarantees, irrevocable letters of credit, it cannot be interfered with unless there is fraud and irretrievable injustice involved in the case, and fraud has to be an established fraud. Irretrievable injustice, which was made the basis for grant of injunction, really was on the ground that the guarantee was not encashable on its terms. There should be prima facie case of fraud and special equities in the form of preventing irretrievable injustice between the parties. Mere irretrievable injustice without prima facie case of established fraud is of no consequence in restraining the encashment of the bank guarantee. So pretty clearly, basically, the law of the land has been the same since 1994. If the court wants to stop a bank guarantee or irrevocable LC from being called, it has to be fraud, which is established fraud, or otherwise a case of special equities, which basically means, there has to be irretrievable justice involved in the case. There's no third exception really. So that's the end of the second decision. Again, if anybody has any questions or if you face similar situations in similar cases before the course, if anybody wants to share any comments, any thoughts, questions. Okay, I'll move on. So the next three decisions are of the Supreme Court, very sort of recent decisions. This is actually a July decision, but it's been in the news for a while because it decided like a bunch of petitions, and generally I think it lays down quite an important proposition of law. Not a novel one, but still quite an important one. So this is the NHAI project director case versus M. Hakim and others. The facts are basically, several appeals were clubbed by the court against orders which modified arbitration awards. Now, for those of you who know, under the NHAI Act, compensation for land acquired to build highways is to be quantified by a competent authority. And if anybody is dissatisfied with the order of the competent authority, whether that's NHAI or a party, they can refer the matter to arbitration. Now, in numerous arbitration cases, in this instance, the lower courts had enhanced the compensation. This was then upheld by the Madras High Court, and NHAI appealed to the Supreme Court. Now, the arguments made by NHAI were that scope of Section 34 is firstly limited to setting aside an award and not modifying an award. Now, for those of you who've attended these webinars regularly, we've seen a number of decisions over the last few months, as you remember, where this has been held by the court, by the Supreme Court or the High Court, that you can either set aside an award or uphold it. You can't really modify it. But we've also seen exceptions. Specifically in the last webinar, we discussed the case where the court actually did modify the award under special circumstances. So there is still jurisprudence on both sides here. So the argument NHAI made was whether the arbitration process under Section 3G5 of the NHAI Act is consensual or not would make no difference to the interpretation of Section 34 of the Arbitration Act versus the NHAI Act. The landowners, on the other hand, said, enhancement of the award amounts were inadequate. They said, NHAI is a state organ under Article 12. It is a state entity. And what NHAI was doing was basically really picking and choosing which modifications to comply with and which to appeal. So they weren't really putting parties on an equal footing. And this is discriminatory. Now, being an Article 12 state government entity, NHAI can't really pick and choose. So they should not really be doing it. The other argument that the landowners made is that arbitration is not consensual. It is the central government which really unilaterally appoints an arbitrator when it comes to NHAI cases. So what's happening really is there is a competent authority which decides the compensation. There is an arbitrator which looks at the compensation, which the competent authority decides, and both of them are appointed by the government. So essentially, it's one person really rubber stamping another brother's decision, and it would be grievous wrong with no remedy if the courts were not allowed to amend the awards. So the Supreme Court looked at the old Arbitration Act, the new one, the NHAI Act, and basically said that if you look at the old Act of 1940, the history to that is it came from a context of mistrust towards private dispute resolution, unlike the new Act. The new Act is, as all of you know, based on the unset trial model law. So the court said there was a conscious choice not to enact model clauses detailing a process of modification of arbitration awards, unlike other jurisdictions. So the court said the 1996 Act cannot be said to give judges the power to modify awards, period. And the court looked at Section 15 of the old 1940 Act, which specifically provided for modifications to an award. But it said, Section 15 of the old Act is not really replicated in the new Act, which is what is based on the unset trial model law. It also looked at some other jurisdictions like England, the United States, Canada, Australia, and Singapore, where there are express provisions that permit the courts to vary an award. So the court said, there are limitations to how you can creatively interpret the new act, but ultimately the petition of NHAI were basically dismissed. Sorry, just before I come to the last point. So the decision of the court is clearly that under the new act, there is no power on a court to modify an award. You either set it aside or you uphold it in its entirety, or to the extent that the law permits you. So while it held this, the court still on fact basis, on factual grounds, dismissed NHAI's petition because it said, because the petitions were so long ago and deals with compensation, they said that, it would be unfair in the interest of justice to really allow the appeal. So the court did uphold what the Madras High Court had done, which was essentially really modification of awards. But the Supreme Court again did so in the interest of justice and the larger public interest. So that's again the end of this decision. If anybody has any questions or any comments, I think we can discuss them now before I move on to the next decision. Okay, the next decision is Gemini Bay Transcription Private Limited versus Integrated Sales Services. Again, this decision has been in the news. It's been around for more than 1.5 months, and there've been various webinars as well actually discussing this because it's quite an important decision. So the issue is basically whether a non-signatory to an arbitration agreement can challenge the enforcement of a foreign award in India under Section 48 of the Act. The facts were that Integrated Sales Services Limited, now that's a company incorporated and registered in Hong Kong, and DMC is an Indian company. Now there is Mr. Arun Upadhyay, who is the chairman of DMC. He and his family control the board of directors of two other companies called Gemini Bay Transcription and Gemini Bay Consulting. So think of this as one group here, which is DMC, which is a contracting party. But the family which owns DMC also owns Gemini Bay Transcription, let's say that's GBT, and Gemini Bay Consulting, so GBC. And they entered into a contract with this Hong Kong entity called Integrated Sales Services Limited. Now, essentially the contract was that ISS would assist DMC in selling goods and services to customers for a commission. So typical commissions contract really. The applicable law was the United States state of Delaware law, and it was a single arbitrator seated in Kansas City, Missouri, the United States. So clearly an international arbitration. The dispute arose when ISS, so Integrated Sales Services, felt that DMC sent potential customers to Gemini companies with an intention of depriving ISS of their commission. So DMC sending customers to the two other companies which the family, which Mr. Arun Upadhyay family also owns, Gemini Bay Transcription and Gemini Bay Consulting. So that's the dispute. Before the arbitral tribunal, ISS prayed for 20% commission. The tribunal found in favor of ISS, applying the alter ego doctrine, and the award was dated 28th May 2010. So you can see quite almost more than a decade old award. Now, the contract was not challenged by either party. Termination of the relationship was not valid as the contract was for indefinite term. So this is the holding of the tribunal said, termination is not valid because the contract did not really have a definite term, so it was for an indefinite term. And the respondents actually failed to prove by reliable and relevant evidence that any specific or reasonable guidelines were established by the respondents, which were not followed by ISS. The tribunal held that since the GPT, so since the Gemini companies inherited these two clients concerning which there is a dispute, it did so inheriting the main contract which DMC had entered into. And it awarded ISS about $6 million, which were to be paid jointly by DMC and both the Gemini companies. So again, the award was issued against three companies, DMC and both the Gemini companies, whereas only DMC was actually a party to the main contract with ISS. So let's get down to the history of the decisions by the High Court. And then because it's a main decision, I'm going to deal with all of the submissions that the petitioners made before the Supreme Court, and then each decision, each point individually and what the Supreme Court said. So single judge of the High Court, single judge agreed with DMC that the award is unenforceable against Mr. Upadhyay and the Gemini companies as they were not signatories, and their participation cannot stop them. Just because they participated in the arbitration as non-signatory does not mean they can challenge jurisdiction now. Division bench of the High Court said the only relevant ground for a Section 48 challenge under the Arbitration and Conciliation Act would be that Delaware law was not followed. However, it did satisfy itself during the proceedings that, the arbitral tribunal did apply Delaware law properly. And they said, all the grounds, conditions have been satisfied. There is no reason to invocate or to apply Section 48 and then refuse enforcement. Now, there were eight submissions made by the petitioners before the Supreme Court. So I'm going to deal with each of them individually because they're quite important. The first submission was that the respondents have not discharged their burden. So now if you look at Section 47.1, generally 47, but specifically 47.1c, the party which requires or which applies for enforcement has to prove why, prove that there is a foreign award and why Indian courts should enforce it. So the petitioner said, that the respondents have not discharged their burden under 47.1c to prove that non-signatory to an arbitration agreement can be bound by a foreign award. The second ground was that enforcement must be refused under Section 48.1a as they're a party under incapacity as they're non-signatories. So they take a lot of grounds under 48.1a, b, c. For 48.1b, they basically said, enforcement must be refused as the perfunctory reasoning of the award would be a breach of natural justice. 48.1c, they said enforcement must be refused as the matters addressed in the award go beyond the scope of the submission to arbitration. Then they go on to say that the award could not be enforceable for perversity in the vital evidence, as vital evidence was not led in support of the claimant's case. So that's essentially in support of the non-signatory's case. And then they basically go on to say that, because this cause of action really arose from tortious interference, this really sits outside the arbitration agreement. So the award is not binding or valid. Then they go on to say that a foreign award would be binding only on the parties. And they do this very interestingly by a comparison of section 35 and 46. And they argue that, if you look at that, it will show that the power of the enforcing court under section 46 is upon persons bound by a foreign award, not really persons claiming under them. And then they go on to say, actually there were no proven actual loss by ISS, so the award should be vitiated for those reasons. Now, like I said, I'm going to take each ground individually and tell you what the court held. So to go back to the first point, the submission was the respondents have not discharged their burden under 47(1)(c) to prove that a non-signatory to an arbitration agreement can be bound by foreign award. The court held that 47(1)(c) is actually only procedural. There is no substantive element to 47(1)(c). And it applies to adduce evidence as to whether the arbitration agreement is a New York Convention agreement or not. There is no requirement to prove that it is binding on a non-signatory. So if you take a step back and look at 47, basically if you have to go to the court seeking enforcement, you need to show that this is a foreign award, it's from a New York Convention country, etc., etc. So the court said that is all procedural. All you need to do is get the original award, show us that it's a foreign award based in a country which has been notified by the government as a reciprocating territory, everything. That's all you need to do. There is no requirement to prove whether the award is binding on a non-signatory or not. So that's essentially what the court said. Now, going on to 48, we'll go with 48 ABC individually. Remember, the submission was the petitioner argued enforcement must be refused under 48(1)(a) as they're a party under incapacity as the non-signatories. But the court said that under 48(1)(a), the grounds are very specific and, among others, speak of incapacity of parties and the agreement being invalid under the law to which the parties have subjected it. And while section 44 uses the word persons, 48(1)(a) uses parties. Now, in two different places, actually, the court drew this distinction between persons and parties. Persons being a much wider concept in terms of, a person can be anybody, but a party has to be a party to the arbitration agreement. So the court said, the grounds are very limited and you cannot have a creative interpretation to sort of go beyond 48(1)(a) to say that, this is a reason for you to refuse enforcement. So going to 48(1)(b), it was argued that enforcement must be refused under 48(1)(b) as the perfunctory reasoning of the award would be a breach of natural justice for non-signatories. The court, on the other hand, relied upon the Vijay Karya decision, and it said that 48(1)(b) was more to do with the right to a fair hearing, and the phrase natural justice has to be read in context and color of the words preceding the said phrase. So the court said, you participated in the proceedings, even as non-signatories. You can't broaden the scope of natural justice now suddenly. It has to be read in the light of what the Supreme Court has held earlier. So it refused the challenge under 48(1)(b). Now, moving to 48(1)(c), the petitioners had argued that enforcement must be refused as the matters addressed in the award go beyond the scope of the submission to arbitration. The court relied quite interestingly on the Singapore High Court decision of Aloe Vera of America versus Asianic Foods, and said that the clause permitted to matters that fall outside the scope of arbitration agreement, not related to parties outside the arbitration agreement. So if your arbitration agreement says 10 things and the award is on 11 things, then that's a valid ground. But that doesn't extend to say arbitration agreement was between these two parties and the award is against these three parties. So they drew that distinction to say, 48(1)(c) is also not applicable. So the next ground, if you remember, was the Torsious ground. The next ground was award could be enforceable for perversity in that vital evidence was not led in support of the claimant's case. The court then held that, the court then relied upon certain decisions and said that if you look at the 2015 amendments, the public policy of India ground does not include perversity of an award under section both 34 and 48 anymore. So they said, public policy is a ground, that's fine, but there is no sub-ground under public policy which you can argue saying the award is perverse. That used to be the case before 2015, but not anymore. So the court rejected this ground as well. The next ground, if you remember, was the tortious interference ground, saying, the cause of action is really from tortious interference or arising from a tort, not really an arbitration agreement or a contract, which is a ground to refuse enforcement. The Supreme Court in this case relied upon the Renu Sagar decision, and it said, under Section 44, the courts have previously held that tort claims can be decided by an arbitrator if the underlying transaction is subject to an arbitration agreement. So if you have a transaction which is bound or which is a subject matter of a contract with an arbitration clause, but then your cause of action is actually from under tort, you could still refer it to arbitration if the seat of the arbitration allows that. So the next ground was basically, like I said, very interestingly, the petitioners had argued that the foreign award is binding only on the parties, and they did this by looking at a comparison between 35 and 46, and again the distinction between persons and parties. So in this case, the court said 46. The court looked at 35 and 46 in quite detail, and said 46 refers not to parties but of persons. And persons could be non-signatories. So parties could be parties to an arbitration agreement, but persons could be anybody really. On the other hand, 35, the court said, is quite limited. 35 speaks of persons in the context of award being binding on parties, as well as parties claiming under them. So 35 would apply to parties to an arbitration agreement and persons claiming under them as far as the award is binding. But on the other hand, 46 doesn't talk about parties, it just talks about persons without restriction. So that's why under 46, an award is potentially binding on non-signatories as well. The next submission was that the award could be vitiated for awarding damages without proven actual loss. And the court basically said that, awarding damages without proven actual loss does not fall, it's not really a ground under Section 48(1). So we can't challenge or we can't allow refusal of enforcement for that ground. Quite interestingly, the court said that, unlike in Section 34, in Section 48, being contrary to the substantive laws of the agreement is not a ground for resisting enforcement. And the Supreme Court made this observation because if you remember, the division bench, like I had said earlier, satisfied itself on whether the Delaware law was correctly applied or not. But the Supreme Court said that was an erroneous approach. The division bench did not really have to do that because this is not a ground under Section 48 to be satisfied on whether the substantive laws are applied or not. So that's the end of this decision. Does anybody have any questions, any thoughts, any comments? Okay, I'll move on to the next and the final decision then. So this is again a Supreme Court decision in Pacer Sequel Terminals Private Limited versus the Board of Trustees of VO Chidambaram Port Trust, Tuticorin, and others. Essentially, there were two issues, both connected, which was whether the arbitral tribunal was justified in passing an award substituting the royalty payment module with a revenue payment module, and whether the tribunal was justified in finding a change in law, which entitled the licensee, in this case that was the PSS Sickle, to invoke a clause of the agreement that I'll discuss now. So by way of background, the appellants, which was PSS Sickle Terminals and others, were awarded a tender by the respondents to develop and operate a seventh berth as a container terminal. And Sickle was to pay the port a royalty based on freight handled, which was of course subject to a minimum. Now, subsequent to the contract execution, and while in the contract time period, a regulatory body called the Tariff Authority of Major Ports was established, and this regulatory body, TAMP, passed certain guidelines on this subject. So the appellants then floated a proposal to allow royalties to be included as an element of cost in its contract. While this was accepted by TAMP, the regulatory authority, but it was rejected by the respondents. Sequel then basically negotiated a shift in the revenue sharing model, citing a change in law, which was through an expert committee nominated to resolve the disputes. Then ultimately, Sequel referred to arbitration, and an award was passed in Sequel's favor. Now, at the High Court level, the single judge refused to set aside the award. but the division bench allowed the appeal and set aside the award. So there was an appeal to the Supreme Court. Now, the arguments before the Supreme Court were that Article 14 of the license agreement provides for amendments to terms where change in law affects the commercial viability of the project. So I think the principal point here is that you could have you could have a different sort of payment terms if there was a change in law being the operative words. The respondents argue that the appellants should be stopped from making certain arguments as they make contradictory arguments regarding guidelines constituting change in law. So just taking a step back, before SEQL referred the matter to arbitration, there was lots of litigation by way of writ petitions before the High Court. And SEQL actually took contrary stances in the writ petition and before the arbitrator. In the writ petition, it said, this does not constitute change in law. But before the arbitrator, SEQL argued that this constitutes change in law. So the respondent said, there should be a stop from doing this. The respondents also argued the tribunal's substitution of tariff model with a revenue sharing model amounts to really thrusting a new contract on the respondents, which is against their wishes. So they said it's quite unilateral that the tribunal can just do this completely on its own. So the Supreme Court did set aside the award, exercising powers under Section 34 of the Arbitration and Concession Act, and they said that the order was perverse. Supreme Court said the award created disparity for the parties and essentially really regarding the unilateral intent of the appellant. And the Supreme Court did this because it said, the arbitrator arrived at its finding based on completely no evidence. It's a case of patent illegality, as there was no evidence to trigger contract's change in law provision. The arbitrator had wrongly substituted the contract's royalty model and changed it to a revenue share model, which really breaches the fundamental principles of justice. And the arbitrator had incorrectly determined that the TAMP tariff order rejection of royalty triggered a change in law. So the Supreme Court said, tariff orders are not change in law. And because the arbitrator thought it so, it really unilaterally imposed a new revenue mechanism on the parties, which is, the Supreme Court said, patently illegal and a fundamental breach of the principle of justice. So that's the end of this decision, as well as all of the decisions for today. I'm going to go back to the update screen to see if anybody has any questions on any of the decision or any comments. Anybody wants to share any thoughts or any experience? Can't see anything in the chat box either. So unless anybody has any comments or questions, I think we can end this webinar. Of course, like every time, if you have any legal queries or if you want a copy of the slides, just email me, jindalvishwam@gmail.com. A recording is going to be available on YouTube for the session. And then we'll see you next Friday on 29th October at 5 p.m. again with fresh updates as well as a panel discussion as well with some panelists and a new topic. Thank you. Thank you, everybody. Thank you, Ram. We liked the session.